Welcome back, everybody. So now we have the really, really nice topic, GDPR, and please take your seat, guys. Yeah, so how are you feeling, guys? Are you tired from lunch? How's the energy level? Yeah. Okay, so so what we do now for the introduction, can we see the panel slide? Ah, okay. I have to do that, I guess. Ah, yeah. Okay. So so each of our panelists will introduce themselves and show some of their hobbies via pantomime. And you guys have to guess what it is. And afterwards, you do the same with your neighbor, okay? So let's try this out. Let's see if we get some energy back after lunch. Who's in to do that? Yay!
Yeah, of course.
Okay, all right. Marcel.
I will start. As long as I'm the only one to start, and then you say no. I'm just kidding.
It's a trick. No.
Okay, I do it.
Piano.
Thank you.
Oh, very nice. Woohoo! And Marcel, I don't know if everybody was here before, so can you just say 2 words? What are you doing?
I'm Marcel, and I'm a panelist on the GDPR panel right now. In my regular day job. In my regular day job, I'm leading a personalization program, and the official job title is Director Customer Data and Advanced Analytics for Lufthansa Airlines, Austrian Airlines, and Swiss International Airlines.
Thank you.
Right. Thanks. So I'll start introducing myself. I'm Sebastian Foucaud. I'm the Vice President Data Science at XING, based in Hamburg. And I lead a team of around 25 people, mostly working on things like recommendation, search, and user modeling. And I have to do my pantomime now, right? Right.
Was that
you.
gardening? Correct. Woo!
Very good.
So I start with the pantomime. So.
Children. Very nice, very nice.
Yeah, so I do have 2 little children. My name is Sebastian. I'm a lawyer. We have a company specialized in GDPR services, and I'm here in the role of the IAPP, which is an association of privacy professionals, and I'm the country lead for Germany. We have 50,000 members worldwide,
Wow.
so that's sort of the global platform on privacy governance topics.
Awesome.
Okay.
Awesome. Nice.
Okay, my name is Herbert. I'm from Commerzbank. I'm head of sales for our customers in small and medium-sized enterprises for southern Germany. So my hobby, let's have a look.
Hiking, yes.
yes.
Very good.
Yeah.
Thank you. Last but not least. Very nice.
Sailing. Thank you. So I'm Felix. I'm co-founder and CEO of Aircloak. At Aircloak, we do data anonymization, something that's very important in the GDPR, in a very special way. And we help, for example, banks or telecommunication agencies, pharmaceutical companies to use customer data in a very safe, secure, quick way without all the compliance hassle.
All right. Thank you. So as mentioned, you guys now do this also to wake up a little bit. Okay, so let's start with one of the first questions. And who's been here the whole event, has heard Zalando, has heard the data ethics panel yesterday. And then basically the question is now GDPR a good or a bad thing? Right? So is it something that helps you to get more, to finally invest into improving your data situation? I mean, as data scientists, data engineers and so forth, we all know that who says they have good data is normally lying, right? So, so is this something that's actually helping you, or as you say, no, we do a lot with customer data and it's really a pain? So let's start with that. An easy question for the beginning, maybe. Who would like to start?
All right. So well, got basically data governance we heard about already several times today, right? And I really think the merge between those two topics, they've been tackling from different perspectives, but very much what I heard this morning is that we need to turn back this enforcement of some processes, because what matters for companies like XING and any other is that we have a good flow of data, that we understand where the data is, where it's coming from, and we have access to high quality of it. And I think there was and there's still an opportunity to use GDPR exactly as a way to convey that message. I didn't like the fact that a lot of companies took it as an enforcement that needs to be done. I think very few companies took it on the positive way. And that's I think, a mistake. And we may come back on that later, but there's also, for me, a missing opportunity with advertising around our customers, that we are doing something good for you as well. So there are all those things that are mixed together. But I think to answer to the question, I really think that it pushed definitely companies to do that, because they had to. Things like the right to be forgotten, or the right to be to remember, enforce that lineage. We need to be able to know where the data of our customers is within the platform, and that has an impact on infrastructure. I know from our friends from Scott that just from there that's something that they have been tackling as well very closely. So all the companies had to go through that. So for me, it's definitely a positive impact, and companies didn't really see it this way and play it that way, let's say, in general.
Thank you.
I think the underlying assumption here is that it is something that's worth doing, right? I mean, just being pushed in that direction in itself is not a value, but the fact that actually protecting the customer data is something that we all feel is something important. Of course, it's a valuable marketing tool, and it's a good way of connecting with your customers in a better way. But nonetheless, it is also something that more and more internationally is considered actually a really important thing to do. Yeah. So PwC recently made a survey where 87% of the participants said they would change their provider, so whether that's a bank or a telco or whatever, if they know that provider doesn't treat their data carefully. So that's a huge number, and everyone has to go in that direction. I think the GDPR helped us a little bit get this into the spotlight, really make everyone aware of it. It gives a nice little incentive to actually get it done. And in the end, there's not much to lose, I guess.
Okay.
So I'd fully agree. I think from a banking perspective, privacy and data security is nothing new. We're doing it since 1870 when we were founded. It's the biggest value we have with our customers. Of course, GDPR tightened it, but especially in marketing, we can do better marketing, more efficient, more customer focused, because we know the customer needs better. So I see more the opportunities than the negative side.
Unfortunately, to some extent, the communication with the customer has not been that positive. In fact, what I, as a customer, see is notices that are hanging on the wall, or a person saying, sorry, can you please sign these 5 sheets of paper, because of this data protection thing. Yeah. That's what I see as a customer, right? Yeah. I'm sorry, we can't send you emails anymore because, or the kids on the pictures of the kindergarten have to be sort of scratched out because you're not allowed to see their faces because of this privacy. EU is doing that, and that's a little bit the shame that the communication has been.
That's exactly my point. Is that there's a missing PR that has been done. Very few companies serve that always correctly, and even from a customer perspective, is that I will. I have advised at the time, a few years back, companies to go even further than this. So provide, some company did it, actually, provide a full dashboard. BBC did it very well, actually, on their platform, where they have a full setups where customers are completely in control of the different privacy settings with a good explanation of why it's done, what's important. And that's what I was saying, is that it came more than to the general public as something that needs to be done, and then actually a good opportunity for everyone. It's not too late to revert it back, to be honest. But I think we should communicate more on the benefit of it from the perspective of the users, but also from the perspective of the company themselves.
Yeah. Let me put in another spin here, just to take an anti-point here. From my point of view, when GDPR came into enforcement last year, we all know it was before, so it was out before, but enforcing was last year. But when it came into enforcement, it left a lot of room for interpretation. in very decisive aspects of your business and very decisive aspects of your data procedures. And that, I think, was not very good. So you had a lot of opportunity to go either that way or this way. This is normal with new regulations coming up. Then courts have to speak, yeah, in essence. But in the face of the maximum fine that you got, you had a problem. My point is, or the spin I try to make here, is that I think lots of investments were, in the end, maybe put into data governance, maybe put into data lineage, maybe put into further hardening your anonymization features, and so on and so on. But many use cases then were not achieved or were not pursued further because of insecurity. And I think that kind of insecurity was, in essence, a problem. Yeah, it's there. You cannot really say, well, how would it have been if it would be otherwise? Because you can only have jurisdiction when you have the law. So it can't be possible the other way. I understand that. But I just make the point, we see a lot of use cases around us not being executed just because of the fear that you might take a wrong path somewhere, and there is lots of room for interpretation in the whole text.
Yeah, and there was a lot of uncertainty as well with the customers. We see that many data, I'm not even thinking about privacy use cases, but just data use cases, right? I just want to do this and that. And many of the customers, especially smaller ones, stepping back and saying, this is currently too hot, like the topic is too hot. And so from that perspective, I think short term, it did actually put a little bit of a stop to innovation. But I hope that that's not something that has to happen long term.
Sebastian, yeah, you
I think it was, can you hear me? I think it was well intended.
That's a good start.
I'm not quite sure whether we chose the right paths that we took at the end, and there were different options on the table, how things should be regulated within the process of GDPR getting finalized, and there were a few options on the table that I consider more technology friendly. I'm not quite sure whether the model that the GDPR tries to enforce, that we have full control on our own data, whether that's meeting actual practice. But is it important to have governance control on the type of data that is being used by companies and also by the public sector? Definitely. And what we're currently seeing is sort of all around the globe, we see privacy legislation stepping up to trying to meet that. But I think as Europe, we have to bear in mind what's happening, especially in the US and China, to sort of do not lose contact to their technology advantages there.
I was told before that a secondary goal of the GDPR was not only to protect consumers, but to create a level playing field. That was one of the secondary ideas, level playing field between the US companies or companies abroad and the European companies. I didn't see that happen, actually. So I saw, as you were describing, a lot of small or mid-caps actually stepping back, stepping away from things that would be there. And the more daring companies are the companies with the deep pockets, where their whole business model depends on if they actually do this in the way. So as I say, the interpretation is either, okay, I do everything I can, or I do everything which is not explicitly forbidden. And then these companies were more daring, and I think this produced more winners and losers situations in the end, and I think that's a bit problematic. So this goal, I think, was not really reached. The secondary goal, creating a level playing field. Maybe it's too early to call, that might be. So 1 year might not be something where regulation really has the final grip on it. But that's my point. And as you were pointing out, the intention was right. I had the data janitor was saying the road to hell is paved with good intentions. Yeah.
But wasn't the level playing field specifically more intended to be across Europe? So the idea being that instead of having a dependency in Ireland, because that's the easiest, it doesn't matter where you are, the laws are the same everywhere, except if you're Austria.
But it was applying to the data subject. So basically the lady or gentleman who is, the individual who is in the EU has to, so there's a reason for, I don't know, the New York Times actually putting stuff behind the wall if you're accessing it from a European server, right? So there's you are in the European Union, so everybody from the US also gets or falls under this regulation. That was my understanding, at least. Is it?
Sure. Yeah, I forget the legal term, but everyone who resides in the EU, right? Even if they're a US citizen. No, I agree. But I think this level playing field idea was very much intended to make it easier to operate in a European market. So instead of having to go from one country to the next. The other point that you mentioned regarding larger and smaller organizations, I think it's not to underestimate that GDPR, and you probably know the numbers on this, but GDPR was one of the heaviest lobbied laws in the history of mankind, right?
Maybe let's touch a little bit more on this, the scaling from EU to a country to a state.
Yeah.
Because what I find also, and maybe you can discuss on that topic more detailed, that even in Germany we have the local DSGVO, and then it's enforced by the state authorities, right? So basically, it can be that it's safe to do it, I don't know, in Berlin or in Saxony or something, but maybe not in Bavaria or in Baden-Württemberg. So can you touch a little bit on that? How do you perceive, because I think there's some insecurity here also on how is GDPR actually broken down into what you want to do on a local level.
Do you want me to answer? So that's a specialty, I would say, of the German market.
Okay.
GDPR directly applies to all data controllers and data processors within the EU, and there might be also cases if you're outside of the EU and offering services or goods to the European market. But if you're residing within the EU, sort of GDPR is directly applicable to your organization, and you're supervised by the privacy authority where you're residing as the data controller or processor. In Germany, we have the case that for constitutional reasons, that authority lies on a state level, Bundesländer-Ebene. So you're supervised by a different privacy authority when you're located in Munich or in Hamburg, for example. And that currently creates some uncertainty because sort of the German privacy authorities, and we have 16 states if I remember correctly, sort of have different takes on a variety of topics currently. I think that will at some point just end because we have a European body that's also new called European Data Protection Board, which can have legally binding opinions on topics on how the exact interpretation shall look like. So I think that's just a matter of time. If you're speaking about pushing investments into data governance, I think we have to split. There are a few areas where I think it's good, it's benefiting for companies and consumers to do like that. You have transparency and where's my data residing? Sure. What do I do with the data? Do I have external vendors having access to that? Do I have proper security controls? Sort of get your organization in order, I have to say, make it. And I think that was just enforcing companies to have proper IT management and data management. And even if some companies didn't like that, I think ultimately that's a good thing. And then there are question of like, how can I access the data? How can I analyze the data? Like, that's the stuff your audience is doing on a day-to-day basis. And there it's getting tricky. And there are different concepts available. And probably this is where the critics are coming from.
That's exactly that's what I heard from what you just said, right? Like I happened to work in 3 different companies during this period of the last 3-4 years, and every time I was discussing with our lawyers or counselors there or DPOs whatsoever, the interpretation was somehow different, a different level. So people, some were taking it a bit more loosely, some a bit more strictly. So there's still a lot of level of interpretation of this, and I think that's where, for me, it falls again back on the business decisions, what you want to do with it. We talk a lot in the past, I think. I just found always surprising because very few companies are done with it, to be honest. We are talking about investing into data governance just as the start. It's a very, very difficult thing to do, data governance properly. And I'm fear that lots of companies are taking it in a way that they put a layer of fresh paint and just saying like, well, we're done now, and then actually it's more profoundly, this is something that is going to go more and more deeper. So it's good that the impulse is there, but it's just the start of the journey, I would say.
Okay, that's a really good point, Sebastian, because so you're saying that basically it's not a one-time investment that had to be made, and then you come up with whatever catalog or with the GDPR measurements, but that's something that is actually an ongoing process. Do you guys agree with that, or do you say, well, no, one time the janitor goes through and then we're basically done, or how are you tackling this topic?
I think yes and no. There have been, I think, two pretty distinct phases in this whole GDPR preparation, and the first one being around March of last year, when everyone was like, geez, 2 years are already over, I need to get this done now, right? And then there was a lot of paperwork, checkboxes, a lot of legal stuff happening. This went a little bit until summer, and I think that's this first phase, and that it kind of has come to a conclusion. Everyone sort of knows roughly what they will have to be doing in the future. Everyone has maybe their whatever their process is set up and all this, right? And now comes the time when we use all that and implement it into new projects, into new products, into new business lines. When we start actually using that, whatever we've been preparing on a paper level, in technology. And that's actually the really exciting part also for us as a technology company. So to some extent, I think we've gone through a first phase. That is sort of over, but now the actual interesting part starts happening. So
the processes are in place, but I hear now and then it's just like, oh, one of our customers actually want to have access to the data.
Yeah.
How we do that,
Yeah.
right? Even I'm talking about last week, right?
Yeah, exactly.
So that's basically the problem is not solved. Yeah. We have the processes put in place, but we're still not in control of our data in general. I'm not talking only for XING, we're doing very good, but in general, I think we still have a long way to go, and it's the right way to go as well.
I think the other thing that has to happen now is that you roll back some of the things that you might have or might not have done. It's like, you know how an allergy works, right? So there's the immune system overreacts. And this is my picture for it, where you say, well, so you have cat hair is flying around, and then somebody, oh, this must be an intruder or something, so must be a wrong thing that cat hair is coming, so the immune system overreacts. And I've signed so many papers, and I've signed and seen my teams signing so many other papers, and to be quite honest, I would assume that, of course, it's not applying for our company, but assume that 50% of the papers that have been signed are actually, from a legal standpoint, actually useless. Yeah, they're just a way of I don't know, of indulging yourself in the feeling that you've done something. Yeah, and that, I don't think that's really good. So you have to roll back these ineffective measures that have been done just to do something, actionism or allergy, and then have to start and sort out what is actually really effective. Yeah? I'm not talking about efficient, effective, really. So I think there's a lot of ineffective measures that have been in place where you thought, okay, this must be this way, and then somebody came and had their amateur image of it, and then I think this needs to be sorted out as well. At least I think, or seen some kind of overreaction on a corporate governance level.
Okay, maybe let's get to the next point. Oh, this is a very, very long text. Yeah, but basically it's about how can you still stay agile if you're fully GDPR compliant. And obviously we are not talking now about the production use cases where you're not using consumer data. Yeah, this is clear. I think if there's no customer data involved, we shouldn't have a problem. But if there is any kind of, if the data is well regarding or affecting GDPR regulations, so you think it's taking speed away from us? You said also that people are sometimes maybe scared and they just do nothing. I remember also your keynote. So how is your perception on that point?
Yeah. So, sorry, I feel like I'm constantly talking, guys. Interrupt me.
It's fine.
So this is our daily business, right? Because the key to this is anonymization, if you can. So we have to say goodbye to the idea that I can just collect all the data that I want and I'm just going to put them all into my big data warehouse or data lake, and eventually some guy is going to, you know, dig through this and find some amazing, you know, nuggets of gold in there. that's not really how it works anymore, and so you have to collect data for a very specific purpose. You have to have very specific and informed consent for that. That is all true. However, you can change these data in a way, you can anonymize them in a way, so that they still retain usefulness, but they are not considered personal anymore. So the GDPR actually says specifically, if data is anonymized, that's by definition not personal anymore, and it doesn't fall within the regulations of the GDPR. So if you're, as a company, you're able to collect information, you're a bank, you need to collect transaction information from your customers, that's your business. Now there are certain use cases that you're perfectly fine doing with that data, but there's a lot of use cases that you're not, right? Your marketing guys, if they want to create a new whatever marketing campaign, maybe they shouldn't access the raw data. And that's exactly where anonymization comes in, and comes in super handy, because if you anonymize them once, at that point you can work with them in any way you want. And you can keep them, you can hand them on, you can monetize them even. Now, the tricky bit here, because that sounds, okay, genius, we just anonymize everything, but everyone who's worked with data before knows that then the data quality usually suffers immensely, right? Anonymization always leads to bad data quality, lots of loss of information in there, and then generating new use cases based on that is can be very difficult. But that's where new technology comes in and actually enables it.
I think it's really interesting, because what I've seen is that many times if you anonymize the data in your certain data sources, then you have a hard time connecting those data again. So how can you solve that, or can you elaborate on that point?
So the answer to that question is yes, it is making it harder to be agile, to be quite frank. If you compare that with a company located in the US, yes, it's harder, because you have the choice to either put additional technical and organizational and legal measures to do that, or you do it non-compliant, or you move the continent. So yes, and I think it's just fair to make sort of that assessment at the very beginning. I just spoke to a friend who's based in California doing data analytics for a company there, and he said even if you take the data away from the US companies, they still have the data models being built, because they just have that competitive advantage and maybe legal advantage. At the moment, the discussion in the legal area and also with technology companies is how can we be agile the same way they can be in the US and in China, and being GDPR compliant as at the same way. And that is sort of a very interesting discussion, and lots of business models are relying on that. And it's basically trying to add technological barriers that allow you to, at one instance, do the data analytics, and on the other hand, sort of try to safeguard the privacy rights of the data subjects. And there's technology available. You have a company that is working in that area. There are other technological approaches to that. But this is a fight that we will see. We will have to probably fight in court at the end of the day, because there will be different takes from the privacy regulator, definitely.
There are 2 points I would like to raise here. The first one is, first of all, not all data is private, so we're still collecting lots of information that is not related to an individual that we use, right? When you do recommendation or personalizations, they actually use very little sensitive and private data, so doesn't fall and doesn't prevent us to compete with other companies. That's the first point. And the second point is, for me, anyway, disregarding GDPR, this whole idea and concept that we should just suck out all the data that is out there and put it somewhere and imagine that at some point in time someone will have the idea, this is just not the way it works. Yeah. We come up with use cases, problem try to solve, look at the data that we can collect, start collecting it, especially in the internet industry. There's no point to store data just in case that maybe someone is going to use it. That costs you a fortune, and no one is never going to come back. And because of the data acquisition is growing exponentially, data that you have collected for a year, you may not collect the same amount of valuable data in 2 weeks. So this whole thing is also not, I mean, maybe because I'm biased towards the internet industry where data is cheap and free and coming very, very easily. It's probably true, but in general, that doesn't prevent us to be agile.
So that's really interesting. So you're saying that it doesn't make sense to just pump your data lake full of data where you might not have the quality or the the level of aggregation or whatever to do a certain use case that you don't know yet. So you're saying basically that the business process, the use case comes first, and then you actually also know what to do. You can also explain to the customer what you're trying to do. Is this the point? Or
yeah, that's my point, exactly.
I would make that point again and say that the one thing first is what I think is what I'm watching out for is now how courts will rule out or rule the berechtigtes Interesse, legitimate interest. I think that's going to be extremely interesting for every one of us. Where are the limits and barriers of legitimate interest? Because that is your legal base, if you want. That replaces a permission, if you want. So now the question is your interest legitimate, yeah, in that what you do, or is it not? And that's going to be only ruled by courts. And you can take the risk, or you cannot. That was my point about avoidance. So no, it does not make it necessarily harder to be agile from my point of view, because you can rely on legitimate interest. It just bears a very certain risk. Now, the other thing that you were mentioning, I think that's important. It's you have to think around your way of asking customers, I think, and you have to also get more. This is my point. I think let's turn around the question. You have to be more agile in receiving and asking for permissions. I think that's the point. You have to have micro permissions for specific use cases. And why not? I mean, my business is doing recommenders for customers and giving them offers that fit. Why not doing a recommender for permissions? Where you say, well, my permission is the product. I want to ask at a time where it fits the customer, where you go in and say, well, is it really right and proper now to ask for this, for that, or am I asking too much here? And this is much about trust. So basically, I would put a no to that and say, you have to rethink what agile means, and you have to become more micro and agile on your way of asking the customer for permission to use the data.
When the business of XING, a part of the business of XING is essentially helping people finding networkers with them or helping people finding jobs. And of course, the advantage that we have is that people are using our product and platforms to find jobs. So they're happy to share the information that will help them finding the jobs at the end. And I think, again, on the missing opportunities is communicating around GDPR, just like, please give us more information, because you can trust that with it, and where you're going to use it to help you. And I think that's the way we should do it. So I'm completely on board with you here.
Very nice. So I want to touch back on this point maybe later, XING versus LinkedIn. I think this is really interesting. But maybe one thing also for you. Okay, this example, you know, who knows Creditec? The company Creditec from Hamburg?
Creditec.
Yes, so there was a story that they, I don't know if it's true, I just read it, that they are actually checking what types of, what fonts are installed in your browser. And if you have this certain font installed, which is actually used in online casinos, they are kind of inferring that you're gambling because because you visited those websites. It's like a saloon kind of, you know, like Western kind of font, and so you get a less well rating on your creditworthiness, and so you don't get the credit, or you have to pay more for the credit. So and this really was a bad thing, right? Because people felt spied on. On the other hand, I know examples from Fido Bank where they were using something they developed called the community karma, the karma score, where they were using information from their online finance community and checking, okay, is this obviously someone who is a good member in this finance community, knows himself around with the products. And they use this information if you opted in to use that, and it actually helped them to make a better offer to the customer. So how do you see that? I think credits is a good source for income as a bank.
Yeah. The best one in the moment, yeah. So that's interesting ideas. So we don't use this in the moment. Of course, we're using external data like Crefo or Schufa in Germany, who are collecting information about companies or private persons, doing a rating for themselves, and it has an influence on our rating for every customer. But that's all we take external. The other parts we use for our credit rating, and we analyze our internal data, like transaction on your account. So when you are a wholesaler and lots of your customer send the products back, you have to pay back. That's a red flag for us, and the rating gets higher.
Credit rating. Yeah.
Sorry. So these data, of course, we use for analytics and for our credit ratings.
But is Schufa score? I think that's a good point, right?
Yeah.
So is Schufa even GDPR conform then? Because can I just ask them to give me my data and delete me or reset my data? Or you're the experts on that. I'm just this is a really honest question. I don't know the answer.
I'm not an expert on Schufa, but they're very, very active in the respective work groups. They're very careful to do this right. That's as much as I can say. And obviously, as a customer, I mean, actually, credit is a really, really easy field to be in from a privacy point of view. Because as soon as I take a credit, and that's actually also why these credit card companies are doing quite well, as soon as I take a credit, I implicitly sign that you can check my credit worthiness.
Yes.
And this check is what gives you, as a bank, a blank check to look through everything.
Yeah.
And
Schufa is storing my data even if I don't want to get a credit, right? Because otherwise, how can they...
But a credit card technically still is a credit, right?
Yeah. Sorry.
No, go for it. A credit card is still technically a credit, even if you don't you don't overdraw it, but it still is one. And obviously this is also why Google and Apple are pushing so hard into the payment markets, because that's exactly the kind of I don't want to say a loophole, but the legal fact that they use in order to be able to work with all your data, because you're taking a credit from them and therefore they're golden.
So if I just use Apple Pay, I'm opting in for a possible credit, and so they can use my data. Is this
in the moment you open an account, you're giving us the opt-in for Schufa, for example.
Okay.
It doesn't have to come to a credit. Yeah? And when something changed in your Schufa information, you open an account with another bank or taking a credit with 5e financial services, we get the info about this, and your Schufa score changes.
Okay.
So for us, it's the easiest way to make credit ratings, and it's the oldest way, I think, for data analytics.
Yeah.
I think Schufa switched their business model, by the way, to legitimate interests, or whatever that is. So they're not consent-based, and one of the reasons is, and that might go back to the initial statement, is it's very, very tricky to get legally GDPR-compliant consent. And maybe Lufthansa and XING are companies who have both direct user interaction, where you trust the companies you're operating with, and there's sort of, for those companies it might be easier to sort of get opt-in for the customers to do certain types of analytics, to sort of make it more customized, make a more customized user experience. If you want to access the meta information Commerzbank has about transaction details, there's no way Commerzbank can go to all those participants that might have personal data in those data flows and ask for GDPR compliant consent. So under those circumstances where the banking industry is trying to make use of that meta information that might have, it's getting tricky to be agile. And they see in those circumstances you need, you have to need to go a step further, and you have to talk about how can we build technological solutions that would survive a court decision on legitimate interest.
Can I ask one quick question about the legitimate interest? So we're all waiting for the e-privacy law, right? My current understanding is that legitimate interest will be pretty much excluded in e-privacy, and much more will be based on consent. Is that true?
There are different drafts of the e-privacy regulation, so we're talking about different types of drafts. There are drafts in the market that solely go for explicit opt-in, which would change the internet as we currently have it.
Right.
Definitely. Yeah.
But then maybe what you said becomes even more important, right? Micro consent for certain things. More that will get much more used to the fact that there will be every now and then there will be a pop-up or something that asks us for consent for specific.
That's if you have the opportunity to look at what BBC did for their platform on their website, but that's exactly where we're going. It's just like basically giving really the ability of our user to understand what they have a dashboard where they can really understand what is the data that they use to a certain level of details that they can really control about it. 99%, it's like the DNCs, right? 99% of the people, they would just click at the big bottom at the top, right? But that's basically giving this liberty and this freedom for the users to really tweak. I think it's very important.
You think your business models will move more in the direction of either a paid service or advertisements? That was also an idea that many people, I think, were throwing around, that basically because they have to get consent for everything now, it opens up a way to get actually much more paywalls into the internet and say, right, you do this, you get everything without data collection at all. You don't have to consent to anything, but you have to pay. Or you don't pay, in which case you have to consent.
Well, XING is essentially a subscription business, so that's not really a problem for us. Our revenue is coming from the people that buy premiums, and then by buying premiums, they consent for us to provide them the best service. So.
I think we will see a decision finally by the European Court of Justice on that decision, on that question, because that is sort of the ultimate decision for all data-driven business models that are customer-facing. There was a decision of the Austrian Data Protection Authority. There was a website, and there still is, der Standard.at. You can Google that, and if you go on that website and you want to read an article, you have to choose. Either you have a subscription, it's like 2 or 3 euros per month, or you can read the article, but then you automatically opt in into that type of tracking. And that was questioned with the Privacy Authority, and the Data Protection Authority said, no, that's fine. You can do that. And there's a broad discussion currently in the legal industry how other data protection authorities see that. And if you look at, Google was fined by the French authority for 50 million euro. That had to do with data privacy notices not being sufficient, but they also said the consent form was not properly drafted. So that goes back to the question. So if that perspective of the French authority would ultimately prevail, that would mean you can't run the Google business model anymore, or the Facebook business model. If you follow the Austrian authority, that would mean, okay, Facebook will have a subscription model, which is without tracking, costs, I don't know, 10 euros. No one buys it because everyone's going to the free model anyway, and opts into tracking. So whoever is right at the end of the day, I think there's so much money behind that legal question that probably will be something that the European Court of Justice will get on the table at the end of the day.
What I like with this idea is that it gets consumers more aware that there is some value in their data, right? Yeah. So I think if you really see, okay, well, either I pay $10 a month or I don't, but they obviously do something with my data. I mean, this I think is actually nice, because I think one big problem we have on the whole topic is that consumers are not aware, right? So everybody says that, no, I don't want to share my data and I don't want my car to know where I'm going, but everybody's sending, I don't know, uploading pictures of their family and everything on Facebook, right? So, so let's get to the next topic. Or Marcel, you wanted to add something?
Fine.
No, okay. So because I think, especially, it's very nice that we have you here from XING as well. So I know a lot of people who are preferring XING to LinkedIn because they say, well, I feel more protected on this platform. I don't know if you can elaborate on that, but I think it's really interesting. So what this question is heading to is, can we, with our regulation, and we had discussion also yesterday in the ethics panel, can it actually be a competitive advantage? Because when we talk about China, okay, obviously maybe they don't have a choice, but in the States, I know some people who don't, like citizens of the United States, who don't want to share their data, but there's actually no competition for them there. So can we actually get some customers from the United States to XING, or how What was the strategy on that point? Yeah.
I just want to open a small bracket on your point on China, because I lived there for a while. And actually, it's even go further than this, that people don't really care. So there's no a cultural value in privacy in East Asia. That is, it's like Japan, China, Korea. There's a more, I'm generalizing it a bit, but it's very much a consensus of people. So there's no notion of privacy as strong as we will have here, and in particular in Germany, right? Close the bracket here, but basically the strategy of XING compared to LinkedIn is exactly based on this, right? Is that I think 2012, 2013, there have been this conscious decision made to focus only on Germanophone market and to go more local. So this is a very strong strategy, going local, close to the people, being the trusted brand on the German market that understands German people, that works with a mid-sized company here, while LinkedIn is this more international platform, right? And that plays on it, definitely. And I think being more ethical, closer, it's a product tuned for the modern German market with the culture involved in it. It goes to an extent that a large fraction of our business is also making events. We have lots of focus on local groups of people, communities, etc. So that's really embedded into the strategy and the DNA of the company to be more local as opposed to LinkedIn. And I think again, but that's not my decision. I'm not unfortunate, but we can play even further the role of privacy and GDPR at XING that we're doing currently. We should emphasize even more, and that's what I'm internally pushing for us to be a bit more going to this direction. But I think from a customer perspective, that's exactly what people expect from us. Just like, trust me with your data. The questions like, should we have the data in cloud? Everything is premises currently at XING, and the main reason is because there's probably a resentment from our user base if we start putting our data at AWS or Google. So it goes to that extent, right? So we are very conscious about it, and that's a strategy. That's really a business strategy. We're still there. I mean, this company is surprising, still there against LinkedIn, right? It's 10 times smaller in terms of employees and still dominating the German market, so that pays.
Thank you. Mm-hmm.
I think this one here will depend very much on as we had before, but also from my point of view, also on jurisdiction again here. So the question here that I see coming up is if legitimate interest is, okay, my business model depends on it, then we would have a legitimization of what you would call nicely data-driven business models, sucking customers' data or sucking consumers' data in, and preparing it in a way that you get it out for, as I know, advertising, where you are the product, basically, as a user. And my point would be that it depends very much. If this is the case, so if we see jurisdiction going in this way, I would say no, this will not happen, this will not help. Because then, if your business model, if your whole essence of your company is being a Datenstaubsauger, yeah, then and if you can rely then, say, yeah, well, but my company's existence depends on this data flowing in, so this is legitimate then this is the wrong direction, of course. Yeah? But I see, or you could have that coming, seeing, for example, I was not aware of the Austrian jurisdiction there, but I think that's going maybe even in the wrong direction, because then you have such things coming up. They were not talking about legitimate interest, but I would have that kind of looking into the jurisdiction, seeing how this is going to be ruled. The other thing about clean and ethical, I would always say it's also about explainable. I think that is from a consumer's perspective, the issue with SCHUFA and credit scorings and so on. You just do not have any clue, and you just are not. It's not transparent to you.
You feel spied on.
I think that's important for many to gather trust, to give the permission, to give the consent or opt-in. That's going to be the XAI, the explainable AI is going to be. Maybe I'm over predicting here. Maybe it's not a trend, but I would bet on that trend. I would say, well, this is going to be a larger thing in the future. If you come for these micro questions, if you come for that, then explainable AI will be a bigger thing, where you say, well, this is why it's working, this is how it's working, and even if you only have the edges of it and only have a glimpse of it, I think that's going to build up trust with consumers. For a reason, I think there are projects which are directed in, well, deciphering the Schufa algorithm by uploading your Schufa statement, and they just try to collect that and understand the AI behind it. So they try they try to overtake from the right side as a consumer activist group, and I think that's only because of the feeling that something happens in the dark.
But just take a slight tangent here, but we're both working a lot on recommendation, and it's actually very clear. The user reacts far better if you explain why the recommendation is made.
Absolutely.
So that's general. People prefer to be informed what's happening.
To me, it depends on enforcement. If you don't see any major enforcement in Europe, if there's no enforcement in other countries outside of the EU, it's probably not a competitive advantage. If we see what's currently happening, that other companies sort of follow the European example to a certain extent, yes, that could become a competitive advantage.
Can you elaborate on that a little bit? Is there...
So Japan, for example, because you mentioned it, now has similar privacy legislation tailored after the EU, and there's an adequacy decision that we can more easily share data with Japan. We see a similar development in Singapore, in the Pacific region, Australia, New Zealand. Even China has now a privacy legislation, obviously not for the public sector, but for private companies. And interestingly, also the US. There was a private group of citizens in California who started sort of a rebellion, rooting for a Californian privacy legislation which sort of had even been more stricter than the GDPR. And the Justice Department in California then had to, in a very short period of time, draft an own privacy law so that local group could not get their own proposal through. And now we have our own own privacy law in California, which will come into effect on January 1st next year. And this is similarly modeled after the EU GDPR. And now the US companies are saying, okay, we have 52 states. And now every state in the US is trying to make an own state privacy law in the US. That's crazy. We would then prefer to have one federal law. So we currently see US companies rallying in Washington to have a federal privacy law. So depending on that might, and a subtext, answer your question around competitive advantage. and one last example from there, you see Apple using privacy as a big differentiator, especially to Google. Google data-driven, and Apple sort of more saying, okay, we give you control on the data, we are more transparent, we trust that you want to have the data on your device, etc. So there you see quite a good example that I think on a midterm basis we will see more and more of that becoming a competitive advantage if enforcement and that legal development should prevail.
I think also, what you're saying with the California Consumer Privacy Act, I think that is actually probably the key to this question, because I always found this argument a little bit difficult to make, that more regulation would be somehow an advantage on a competitive level. No, if you're not regulated, you can do whatever you want, then you can build any business model that comes to mind, right?
Sure, I think the idea is rather that consumers are choosing your service because they feel more protected.
Right.
Like a lot of XING users are choosing their service over LinkedIn because they say, well, I don't want to give my data to Microsoft or whatever, right? So.
Right, exactly. But then your service, you have to get so many more consumers that whatever you lose because you're constricted by this regulation is negligible, right? That's the issue.
Well, okay. But in that case, that's the positioning, right?
Sorry?
It's a positioning. It's just saying like
exactly.
we are not competing with LinkedIn. We are providing our user base something that is different, like similar goals, networking, jobs, etc., but fundamentally a different product that is closer to you.
Right,
that's the positioning of the company. We're losing nothing.
Yeah.
Because if we had confronted LinkedIn, probably we'd be dead.
Exactly. That's how you're positioning yourself. But I think it can actually become a real competitive advantage for European companies or companies that adhere to GDPR right now, because laws are changing internationally and because people are starting to think in different directions. We get I would say 1 call a week from Brazilian companies who are now starting to worry because they will get new regulations. Where do they go if they need to solve their privacy problems? They go to Germany. These guys have figured that out 50 years ago. There's a company that does exactly this. Let's talk to them. So this is already happening right now, and it will become only stronger. And if we're starting to build real AI expertise and machine learning expertise that is actually privacy preserving, once that time comes, if it comes, right? If globally more and more of these regulations will be active, then that will be a true edge that we can have. Simply because we're restricted now, we need to work under these constraints, and if these constraints grow, then that's the point at which it unlocks.
That's really cool. So we will actually be first ones. Okay. So just one last question, then we have to wrap up and open up we would like to open up to the audience. So this is obviously a provocative question. So do you think that you touched a little bit upon Sebastian on the topic of prosecution, right? So is there, like, are people sued a lot already? Do we have this, that this blogger has to go to jail because he didn't really check his GDPR, organize his data from his users? So how is it, what is actually, have there people been really sued the last year? Can you elaborate a little bit on that? What do you think?
Enforcement is starting. So we are currently in the phase where privacy authorities are sort of getting things started. You have to understand that first companies were overwhelmed by GDPR, then the whole consultancy business, and then the privacy authorities. so in that way, they were all drowned by questions and requests. And they're now sort of stepping up their game. They, for good reason, they did not want to start sort of with, we had enough panic in the market, I think, to not start immediately with high enforcement mechanisms. But now, and the legal machine takes some time. But yes, we saw the first fines. Speaking with privacy authorities, they say, okay, expect more to come. It will take some time to sort of level out the different approaches of the privacy authorities in terms of the fines.
How much is such a fine?
2 to 4% of global revenue, but still that is legally debated. Global revenue, how do you define that? How you define sort of the legal operations behind that?
2% is the minimum then?
No, that's the range depending on,
the maximum
it can be less, be less. The Dutch privacy authority has, today's Thursday, on Monday, released a statement where they sort of came up with a framework saying, okay, that type of breach costs that type of money.
Oh, okay.
And that is going to be debated by the European Data Protection Board. And it won't be exactly, that's already what we heard, that type of proposal that the Dutch came up with, but we will see at some point of time, I guess early next year, the European Data Protection Board issuing, okay, that type of breach costs that type of money. Okay. At the moment, the range is something between €500 and €50 million, so that's not a big help for the companies, but expect it to be more expensive than it used to be under the old legislation.
I think it was remarkable that the French authorities gave the first fine to talking about the talking about the level playing field, gave the first fine to Google. Talking about level playing field, and German authorities took I think the first fine to Knuddels on about 20K. So that was a really low approach from my point of view. Apparently the delinquent had worked with them so far, as I understood. But I thought that was remarkable from the aspect of the secondary goal level playing field. There was a total difference in attacking or having a kind of, I don't know how you would call that, a merit order or something. There's a difference apparently between German and French.
Not only compared to
guys, sorry, you see all these people. We have to. Yeah, it's super. So thanks a lot. So give a big hand first for this great discussion. And also the great